For the record again, my name is Medad Lubega Sseggona. For the applicant, with the assistance of all counsel mentioned earlier. The application, my lords, is brought under sections 98 and 100 of the Civil Procedure Act.
For how long do you intend to address the court?
My lord, I would intend to address you for an hour, but I would be guided by your direction.
That is interesting. I thought you were going to ask me for 10 minutes and finish in 6.
My lord, I must...
Well, I give you half hour, 30 minutes to submit, and don't make me exercise the other power which I have to ask you to sit down. 30 minutes, you'll be done.
I thank you, my lord.
And the responses will also be 30 minutes for each party. You will have 10 minutes then for any rejoinder, if there is one. And you know the rules about rejoinder.
I'm properly guided, my lord.
Yes, so use your 30 minutes. I'm beginning to time you.
I will
right
as
now.
well endeavor to use less, because there is an indication from court that you want me to use less, and I will do that, my lord.
No, you have the 30 minutes is yours. Don't be intimidated by court. Just use. Don't get stampeded.
Thank you.
Use the 30 minutes.
Thank you, my lord, for the assurance. My lord, this application is brought under sections 98 and 100 of the Civil Procedure Act, Cap 71, rules 15 and 17 of the presidential elections, election petition rules, and rule 2, sub-rule 2, as well as rule 5 of the Judicature Supreme Court rules. It seeks for the orders mentioned that the filing of additional affidavits in the petition is necessary to enable this honorable court effectively inquire into and determine the questions involved in the petition. 4, that there are prevailing special circumstances to warrant the grant of the application, and that the application is brought without delay. 6, that the respondent shall not be prejudiced by extra time being granted to the petitioner to file additional evidence in the petition, and finally, that it is in the interest of justice. It is supported by 2 affidavits, my lord, of the applicant, the Honorable Sentamu Robert Chagulanyi, which is accompanying the application, and that of Mr. Anthony Yeboah Wameri, who is one of the lawyers involved in the petition and therefore conversant with the matters before the lordships. I am required by lords, by presidents of this honorable court and other courts, to prove special circumstances that justify the grant of your exercise of discretion. The special circumstances, with your permission, are contained in the applicant's affidavit, in particular, paragraphs 18 to 22 to paragraph 24 of the petition. It is true, my lord, that this court gave directions when we last appeared, which the petitioner / applicant was not able to comply with, and not out of his own motion, but because of the circumstances that he has alluded to in those paragraphs I've referred to. 1, that a number of his witnesses were not released on bail as anticipated by the General Court Martial and other places where they were being held in detention. 2, that the part of the evidence which was locked up in the offices of the National Unity Platform could not be accessed, and that the military siege over the offices was only lifted on Sunday, the same day, evening, the same day he was supposed to have concluded with the filing of the affidavits, and could only be accessed on 15th But nonetheless, he worked around the clock to get evidence from alternative sources, but could not do and conclude in time. 3, my lords, that's under paragraph 21 of his affidavit, that he was only able to access some of the witnesses in prison on Sunday, having been cleared on Saturday night to be able to get evidence from these witnesses who are incarcerated in prison. That a number of would-be witnesses were thrown into distant places from Kampala without money and transport, which imposed an onerous obligation onto the petitioner and his team to go and collect them so as to be able to access the evidence. And my lords, these are thrown by abductors who are state actors. My lord, those circumstances notwithstanding, by close of business, as indicated and directed by this honorable court on 14th, that is the Sunday we were supposed to have filed, he had been able to collect the evidence, the affidavits, but could not submit all of them on the clock. He continued, according to the affidavit of Anthony Wameri and the applicant, to come in with affidavits until he found the gates closed. My lords, that those are special circumstances calling for your intervention. The evidence that the applicant seeks to bring, my lords, will help this honorable court in effectively and conclusively determining this matter. In the summary of what that evidence seeks to produce or to bring before court is contained in paragraph 32 of the applicant's affidavit, which, with your permission, I would like to read verbatim. That the additional evidence I obtained from about 200 witnesses across the country is necessary to enable this honorable court effectively inquire into and determine the questions involved in the petition, in that A, it brings to the fore the various abductions, imprisonments, torture, murder episodes of the petitioner's supporters by agents of the first respondent and the third respondent. B, it reveals how results declared by the second respondent were falsified in favor of the first respondent. C, it brings to fore the various cases of bribery committed by the first respondent and his agents. D, it brings to fore the second respondent who was compromised by the authority of the first respondent, abusing the power of incumbency. E, it portrays the audiovisual expression of how the agents of the third respondent selectively enforced the electoral guidelines and used excessive force to frustrate the petitioner's election campaigns in favor of the first respondent. F, it brings to the fore instances of voting in the names of deceased persons and persons out of the country. G, it brings to the fore how the second respondent relied on incomplete, improper, and incoherent voters' register in the election. H, it brings to the fore how the second respondent unlawfully, inefficiently, and covertly deployed biometric voter verification kit, BVVK, and electronic results transmission and dissemination technology systems, ERDTS, without access by the petitioner, denying him the right to verify voters and audit the results. Finally, I, it brings to fore how the petitioner's stronghold district cities of Kampala, Wakiso, Mukono, Mpigi, Gulu, Masaka are not the first respondent stronghold districts of Kiruhura, Isingiro, Bunyangabo, Kazo, Kamwenge, Chankwanzi, were the epicenter of the intimidation and violence against voters and how they affected the percentage of voter turnout in favor of the first respondent as against the petition. My Lord, this evidence is important. My Lords, timelines are important in this petition and therefore as necessitated by the application. It was envisaged that there would be situations where an applicant would be curtailed and not therefore unable to comply with the directions. But all effort has been made, my Lord, getting all the 200 affidavits, commissioning them, binding them, and producing them within the time limit was an onerous hurdle. Luckily, those affidavits are ready. They only await your permission. The respondents, my lords, have filed affidavits in reply. The unique one, though, and this is where I would make my very best attempt in approaching the affidavits in reply. The most unique is the affidavit of the registrar of this honorable court. Unique in a sense that in my practice, I have not come across and therefore been confronted with an affidavit from court. In the event that I do not do a thorough job in this, please pardon me, because it has an effect on my adrenaline. That said, I continue to be fortified and assured when your lordship, the Honorable Chief Justice, said I should not feel intimidated. Let me look at the affidavit of the first respondent. The first respondent has filed an affidavit through Mr. Sseggona Isao, filed in this honorable court yesterday, 18th February 2021. In effect, it only talks about failure to file the affidavit as directed by this honorable court. True, my lord, they were not filed as directed. And I would invite this honorable court to look at the affidavits in support, not as affidavits that seek to paint a wrong picture on the court, but only explanatory of the circumstances. Explanatory in a sense that the express inability, and therefore the responses do not answer the question of inability, and therefore how compromised the circumstances were for the petitioner or applicant to be able to comply with the directions of this honorable court. The second, my lord, is the affidavit of the Honorable Stephen Tashobia, Commissioner, on behalf of the second respondents, or the second respondent in this matter. He only brings in matters that, like I said earlier, are alien to me and are not known to me, and I have not been gifted with evidence of the alleged statement by the applicant. The circumstances could not permit a rejoinder because, like I said, I received this on my way out of office yesterday evening, and it was not my intention to continue delaying the process of hearing this application. That said, my lord, Honorable Stephen Tashobia does not attach evidence with respect to the conduct of the applicant, which gives him the basis of stating, as he does, that this application is brought in bad faith. I invite your lordships to consider, and only be pleased to consider, matters that are placed before your lordships. Anyone with extraneous evidence should bring it, other than engaging this honorable court in a series of rumors. I submit that without evidence, what is alleged as against my client or the applicant to constitute the grounds upon which Honorable Stephen Tashobia believes in paragraph 21 of his affidavit that this application is one brought in bad faith and an attempt to mobilize the public against this court should be discarded, disregarded, and rejected. Why, my lords? Because they lack evidence. 2, that the applicant has not been heard on this particular fact. We also think, my lord, and this I owe as an officer.
Mr. Lubega,
Yes,
you began with the affidavit of the registrar of this court.
Yes, ma'am.
Now, I want you to address us on what Council Wameli says transpired on Sunday the 14th and what the registrar says. Where they are at variance, I really want you to address me on that.
Wait, my lord, I'm fortified. I'm grateful that you have permitted me to address you on that.
Yes.
Like I said earlier, first of all, it gives me enormous difficulty addressing an affidavit of court.
No, that's not the affidavit of court. That's the affidavit of an official of the court, sworn. And if I swore an affidavit, you could even insist you want to cross-examine me, in which case I would have to stand and be cross-examined.
How I pray it doesn't happen, my lord, in my remaining time of practice.
Then I shouldn't swear, or I shouldn't be a witness.
I would have advised that way if I had known that the registrar was about to swear one. That notwithstanding, my lord, and that said, I am not, as an advocate, in a position to cast any doubt on an affidavit sworn by the registrar of court. I disclaim that ability, my lord. I come to court with a tone.
No, let's sort that one out. I know the difficulty you think you have. There should be no difficulty. Council Wameli, if I remember, I read his affidavit the other day. He says he came with volume 2 and the other volumes on Sunday the 14th. And as they were registering volume 2, time caught them. I'm paraphrasing. So he could not register that volume now, and came back the following day.
Yes,
but the register says he came with volume 2, but only 7 copies. And she then sought my direction, and I can tell you I was here both Saturdays and Sundays, leaving at 7 p.m. or thereafter, both days. What to do, because there were only 7 copies, 3 of which were given to representatives of the council, the respondents. And then she says I gave her directives to extend the time up to 6 p.m. for purposes of receiving the additional copies of volume 2. That is her affidavit.
True, madam.
And they did not beat it. She sought my directive again, and she says I directed her, let them file first thing in the morning, which they did, and that's when they came up with the other volumes. Your learned friend says something different.
My lord?
Yes.
I thank you.
So either the registrar is lying, or your learned friend is lying.
My lord, my eyes have not gone that far to make a conclusion that one of them is lying. My reading of the 2 affidavits, however, drive me to one conclusion, that the affidavits were not presented to the registrar. I think the beginning point, with your permission, would have been to be guided by Rule 13 of the rules of this Honorable Court. Because what Rule 13 provides, if you permit, I'll read: acceptance of documents lodged out of time. The registrar of the court, and they say here the Court of Appeal, as the case may be, shall not refuse to accept any document on the ground that it is lodged out of time, but shall mark the document with the words lodged out of time and inform the person lodging it accordingly. When the document is accepted out of time by the registrar of the court, he or she shall inform the registrar. I suppose they're talking about the registrar staff informing the registrar. Mm-hmm. And what that would do, my lord, is it would impose an obligation onto us to formally apply to this Honorable Court to validate, if you find pleasure in the application. What Mr. Wameli says is that I came with them. The registrar says, no, I did not receive them, and it is true.
No, the registrar doesn't say I did not receive them. The registrar says he came with volume 2 only, but even those were not in sufficient numbers.
My Lord, and
the
that is not
registrar says
rebutted.
the first time he came with the other volumes, I think they go up to, I can't remember, was Monday, 15th.
True, my Lord.
That's what the registrar says.
And that's what
Your
I
learned friend, Mr. Wameli, says he came with all of them. That day, the registrar, time caught him as they were registering, and the registrar declined to something like that.
One, they were not submitted to court.
No, were they brought to court on Sunday? Because they came from your law firm.
We did
Were
dispatch.
they brought, did you have them ready on Sunday? They were brought to court. For some reason, the registrar
Not by
did
5, my Lord.
Hmm?
Not by 5. And that one is considered.
By what time?
Beyond 5, yes. Because we started sending volumes before 5 o'clock. And we continued sending until the time when they said, no, the gates have been closed.
When was that?
That is Sunday evening, my Lord.
No, what time was that?
By the time they closed?
The registrar is very clear
Yes.
that the Chief Justice directed her that if they have already brought copies of, which was volume 2,
Yes.
then extend by 1 hour for them to bring the other copies of volume 2.
True, my Lord.
They failed to do that. They sought the direction of the Chief Justice again, who said, fine. If they are not able to bring the remaining copies of volume 2, they can then bring it Monday morning.
And my Lord, I find not difficult.
Nothing to do with other volumes.
And my Lord, I find not
Actually,
difficult.
no suggestion that there were other volumes, either in court or still remaining outside.
I find no difficulty, my Lord, in conceding that the position of the registrar is the correct position. They were not produced in time.
I think so, yes.
Yes. And my Lord, I'm trained to concede
Yeah.
and appeal.
Okay,
To
now,
your-
fine. You submit on the
to your
merit of the
conscience.
application. Yeah.
So, my Lord, we pray that you be pleased, as you've been pleased in other cases, to extend time. Permit me, your Lordships, to refer to the authority we have touched. In our bundle of authorities, it is page 42, and that is authority number 6, and that is Joseph Initiative Limited versus Akugizibwe Jocelyn by the Honorable Justice Gadenya Powa Limbwa, which I invite your Lordships to be pleased to consider. At page 48, my Lords, to page 49.
What was the nature of the matter before court then?
It was an application, my Lord, for extension of time. And that is what we are here for.
In what? In civil matter?
Yes, my Lord. No. My Lord, it was a judicial review matter in a civil matter. It is miscellaneous application number 51 of 2018.
Yeah.
And he reads, my Lord, he writes at page 48.
The court had a timeline here. We all agreed to it here. What permission was being sought from the registrar to extend the timeline?
Well, my Lord, to receive. And
To-
that
to-
would
to
give
what
us an
purpose?
opportunity.
To what purpose?
The same documents we are talking about, my Lord, which had been brought,
To receive and give you an opportunity to
we would file, to expedite the process, we would file
Why
an application.
Why didn't you then file an application 8 o'clock in the morning of Monday the 15th, knowing that you were out of time, the timeline we had indicated here? Why didn't you begin with an application? Or why didn't you file an application on Friday 12th? Say, look, we now know we will not be able to beat the deadline. I would have constituted this court on Saturday to hear that application.
Thank you, my Lord.
Yes. So did you need to ask the registrar for that when you knew very well that this is the timeline?
First of all, my Lord, I thank you. It was improbable to think that we would fail, because it is evidence that keeps trickling in. Secondly, my Lord, and why we could not file on Friday, at that time we are still preoccupied with beating the deadline.
What do you mean evidence that kept trickling in?
My Lord, evidence comes from across the country.
Yeah, but you told me your witnesses were in jail, so how could evidence...
No, there were
be-
quite a number, and we continued securing release of a number of them. Those that were abducted were being thrown on the streets. We would pick them, and we get evidence. You will find it if you permit. Those that were in jail, we were continuing to pursue their bail applications. If, again, as the evidence of record indicates, we had a bail application where which was only fixed for Monday, a day after the deadline, and we were continuing with all efforts, my Lord. But why we did not file again on Monday, on Sunday before? Yes, we were preoccupied with gathering evidence in the hope that we would be able to beat the deadline. We were not in a position. But we also thought that the affidavits would be received with this indication, whereupon we would quickly file an application for validation, and we had it in mind. And we do not want to blame court, my Lord, for not receiving. We only say we had this, not misapprehension, but this thinking that they would be received. Now that they were not received, my Lord, the option that was left for us was to file an application. And by Monday, we were still hoping to have them received. Tuesday was a public holiday. Wednesday, we filed.
But Mr. Lebega, you are saying if it was not received, you would not be able to file an application?
No.
Was filing an application contingent on the registrar first receiving and endorsing that this was brought out of time?
Yes, my Lord.
Or you could file an application anytime?
Yes, my Lord, because these are two different applications. If they are received, the application would be a different one for validation. But if they are not received, the application would be the current application, my Lord.
Yes.
So it definitely had to be dependent.
Okay,
on where they are received.
then you have a copy of this application of yours?
I do, my Lord.
Yes. Can we go to the first page? There is a stamp of the Supreme Court on mine. I suppose it is on yours.
On the application, my Lord?
Yes. On the motion, on the notice of motion, there is somewhere up there. I don't know where yours is indicated.
Of which date?
No. Do you have a copy of yours?
Yes, my Lord, I have a stamp of 17th.
Yes.
Yes, my Lord.
Does it indicate time?
No, my Lord.
Oh, it doesn't?
It doesn't, my Lord.
Can you borrow mine?
My Lord, I would receive any information from you without taking
No.
it.
I want you to look at it. Don't mind, I don't have corona, but
No, my Lord, I don't want to infect you either.
I test myself every 2 weeks.
My Lord, I equally do not want to be accused.
So kind of you.
My Lord, the court supplied me with a defective bottle of sanitizer.
Oh.
I would appreciate if someone...
Maybe you don't know how to operate it.
Or I'm not strong enough to press.
No, you loosen a little bit first.
Oh, thank you, Lord. My Lord, it has an indication that it was filed at 17 hours. Presumably that's...
In the 12-hour clock, what time would that be?
It would be 5 o'clock. 5 o'clock.
Yes.
May I have it returned?
Thank you. My question is this really. Yes, on Monday you filed, you tried to file affidavits which you knew were out of time. Which happens, it does happen. I'm not saying this is the first time such a thing happens. No, it happens. If you persuade me, of course I'll give you additional time. If you don't, I will not.
My Lord, I'm here to do the latter.
My question is, yes, you are here to persuade me, yes. So Monday, you knew you should have, you did not. And the mistaken belief that you should first of all hear from the registrar and then make a decision on what to do. You discovered that the registrar will not receive it. Tuesday 16, you did not come here. I can tell you that this place was open, but you did not come because it was public holiday. Can you explain why you did not file the application first thing in the morning of the 16th? Why would you come and file the application 5 o'clock? You filed the other affidavits 5 o'clock, including the ones you told this court on some record that you had 50 affidavits you were even prepared to file that day. You filed at 5 o'clock on the last day. Can you explain? I mean, what is it really? Not some game plan or what? I mean, why wouldn't you file, if you had filed those affidavits, which would have served on the other side, they would have started the work of respondent. Then you would not have been filing the 50 affidavits on Sunday. You would have come to me and say, my Lord, I gave my word that the following day or soon thereafter, I will file another 50 affidavits. It's become a lot more difficult. And these things happen. Don't think we don't know. We know they're difficult. Anything can happen. So why must you always come at 5 o'clock?
My Lord,
what is the magic wand about 5 o'clock?
First, my Lord, there is no magic about 5 o'clock to begin with. 2, my Lord, yes, any delays are regrettable on our part, and we do not want to justify them. To the extent that the question is being asked to counsel, you will permit me to answer from the perspective of counsel.
No, I'm asking, because it is your law firm. I cannot ask the petitioner. This is directed to you. He has entrusted you with the responsibility to represent him professionally. And I notice a pattern, which I've just mentioned. Even when you gave your word, you did not honor.
My Lord?
Yes.
To the extent that I must, as counsel, to answer this question, the answer will not be found in the affidavit, but it will come from me.
You are an officer of this court.
I
would take your statement seriously.
I attempt to practice law professionally, that I avoid alarming statements. It is now my time to tell you that for the last 3 weeks, I have not been working from my office. I have not been sleeping in my house, to avoid situations of 2016, where affidavits which were supposed to be filed in this court were stolen.
You don't even have to submit because we have it. If the affidavits, even if they were 1 a day, or 2 or 3, we can understand. What I don't understand is, you have the affidavits, you assure this court, as an officer of the court, I have these 50 affidavits. Even today, I hope I'm not mispresenting what you say. Then those affidavits do not come. They're the ones that come. Do you want me to tell you? Your team came on a border at 4:35 outside here. Because I was here. I want to make sure that there are no hitches. Because to me, a presidential election petition is a very important thing. I don't have to restate. And as I told you the other time, it's not about the petition. It's about your country. It's about my country. I have children, you have children. I beat you 1 notch because I have grandchildren. I don't want them to see what I saw from independence. If I can make a contribution, that my grandchildren live in a country where they think it is some fairy tale when we say this used to happen, I would be very happy. So I was here, and that's why the registrar was seeking my direction at every point. Because this is important. 4:35, they were outside. They didn't come in a vehicle, in two borders. I don't know whether they were personal motorcycles. Ask them, they will confirm.
My Lord, it is true.
So I don't understand. You know what? I don't know what the game plan is. I really fail to understand.
Permit me, my Lord, therefore, to respond to that, because it is critical and important. First, to appreciate you for that resilience, but also to note my lord, that lawyers are flying on borders from all directions to bring these documents would demonstrate the effort on behalf of the applicant and his lawyers to be able to file the documents as required. Number two, my lords, all the questions that you have raised are very important questions for the determination of this, and I need to justify or explain why. I am not represented as having said that we would be be able to file those affidavits on that day. I am not misrepresented. We left the court past 1 o'clock, and we had a duty to collect all the affidavits from wherever they were being worked on and bind them and make them ready. But it also occurred to us that we needed to be neater, not to keep throwing one affidavit after the other. You may witness that there are some affidavits which were filed on that day, like the affidavit of Joseph Kableta from different lawyers who were making them. But we thought the record of this court would be more organized if we filed in bundles. And that, my lord, is my reason, although admitting, yes, that we should have done what you're guiding we would have done.